government would have probably a take on the matter that is quite different from the perspectives that will be shared by the plaintiff and the Attorney General. For example, some of the points that Kweku has raised in his intervention in this matter are not necessarily matters that were canvassed by either side of the case, right? So, if you allow the speaker to submit, to make a submission, I mean, the court can do this by, you can even invite it as an amicus. You can join them. You can invite that as an amicus. However you do it, I do think that in these matters where there are third-party interests, and those third-party interests are real, not just nominal, that the court must find a way to join those parties or invite them to make a submission in the case so that the court has a full measure of all of the perspectives and arguments that may well be canvassed in this matter.
Yes, Prof. And I ask if there is not a practical problem in this situation, if there's not a practical difficulty, how is Parliament going to be part of a process that it is divided about?
It doesn't matter. I mean, you can have, if those persons who are in Parliament, for example, if you invite amicus, they could go on either side. If you invite them to submit this as an amicus, right? The speaker and others who take his view can submit one that takes one point of view. The deputy speaker and others can submit their brief that take another point of view. So it doesn't really matter. I think that we are inclined to see legal disputes only in a binary fashion, that there is only two sides. There could be 3 or 4 sides, right? For me, what is important is that in an adversarial system of justice, the lawyers or the parties that are before you, you must make sure that they are the ones most suitable to advocate most strongly the positions that they are advocating, so that you, as the judge, will have the benefit of the best possible arguments, all of them, and then you make a decision based on...
The law allows any party that feels affected. The law allows any party that feels affected by an ongoing matter to apply to join.
Absolutely. In fact, I have raised this question even before this judgment came out. When I saw the case, and I thought, well, where is Parliament in this? Where is the Speaker? I actually expected that the Parliament or the Speaker, at the very least, will join the matter, because that window, that opportunity is there. So for me, I was a bit startled that Parliament had not actually found it expedient.
What that tells me, Prof, is that, and this to the both of you, what that tells me is that the Parliament felt that the two sides of the coin, was represented in courts. The minority side, side by the plaintiff, and the majority side by the Attorney General. And so they didn't feel the need to do anything.
I disagree with this is where I have to disagree with the conclusion that Professor Asare draws based on the absence of representation of the Speaker, that because of that it renders the whole matter, the whole outcome nugatory. I don't think it does, because in fact there was that opportunity. There was that opportunity for the Speaker or any other party in the House to align with one or the other side, or to actually take a separate view and join this matter, apply to join this matter. And to the extent that they basically felt that their point of view was adequately represented, albeit erroneously, by one or the other side, I do not think that that in and of itself is sufficient to actually vacate